You know, if you've ever lived in a community with a residents' welfare association or an RWA, you've probably felt it at some point, that little bit of tension between the community rules and your own rights as a homeowner. Well, today we're going to get right into it and figure out exactly where the law draws that line, and we'll use a real-world case study to see what an RWA can do and what it absolutely cannot.
So let's just jump right in with a big question. Can your RWA actually tell you who you're allowed to rent your own property to? Can they demand that you hand over a copy of your lease? You know, that private legal contract between you and your tenant? And hey, these aren't just hypotheticals. For one RWA, this stuff became official policy.
Just take a look at this. This is a direct quote from the actual meeting minutes of a residents' association. They didn't just ban what they call multi-tenancy, which is basically renting one property to several unrelated people. No, they went a step further. They decided to apply this new rule retroactively, potentially forcing homeowners to break contracts they already had in place. This is exactly the kind of overreach that brings these core legal questions into such sharp focus.
Okay, so to really understand why a rule like that is so problematic, we've got to establish the fundamental legal boundary here. What power does an RWA actually have?
Honestly, it's a lot simpler than you might think. Under the law that governs these associations, their authority is really limited to just two things. One, managing common areas, we're talking parks, roads, community centers, and two, enforcing existing government safety laws. That's it. Their power literally stops at the front door of your private property.
I think a fantastic way to think about this is the castle and courtyard analogy. Your home, that's your castle. The RWA, they're the guardian of the shared courtyard. So yeah, they can set rules for the courtyard, you know, the common roads, the lifts, the community center, but they are not the ruler inside your castle. Who lives in your home? The terms of your rental agreement, that's all your domain, period. So, with that castle and courtyard idea fresh in our minds, let's take a closer look at the three specific rules that the RWA committee, in our case study, tried to pass.
First up, the big one we've already touched on, the outright ban on multi-tenancy.
Now, what's fascinating here is just how clearly this fails the legal test. This rule directly stomps on the Transfer of Property Act, which gives you the fundamental right to lease your own property. It's what lawyers call ultra-virus, which is really just a fancy way of saying acting way beyond your legal power. An RWA simply does not have the authority to create a rule that overrides national property laws. All right, next, the committee demanded that homeowners had to submit a full copy of their rental agreement before a new tenant could even move in. So here's the deal. A rental agreement is a private, confidential contract. I mean, it's got financial details, personal clauses, stuff that is frankly none of the RWA's business. Now, sure, they can ask for basic tenant details for a security check. That's reasonable. But demanding the entire contract? That's a massive overreach and a huge data privacy risk for the association itself.
And finally, of course, we get to the money. The committee rolled out a series of new fees, and get this, they were aimed specifically at homes occupied by tenants.
First, there was a non-refundable move-in fee of 2,500 rupees for every single new tenancy.
And on top of that, a monthly surcharge of 250 rupees, which was added to the maintenance bill only for homes that were rented out.
Okay, this surcharge is on really shaky legal ground because, well, it looks a lot like a penalty, not a fee that's based on actual costs. Think about it. If you have two identical homes using the exact same common facilities, you just can't charge one more than the other because the person living inside is a tenant instead of the owner. It violates this core principle of ownership parity, and it seems punitive, creating a huge risk of it being challenged and overturned in court. Now hold on, this doesn't mean RWAs are powerless. They can make new rules, even ones that are pretty restrictive. But, and this is a big but, there are some very specific legal hoops they have to jump through first.
You see, the problem with the rules in our case study wasn't just what they were, it was how they were made. You can't just get a majority vote at a meeting and make an illegal act suddenly legal. It just doesn't work that way. You absolutely have to follow the procedure laid out in the law.
As you can see, the bar for creating a new, legally binding rule is actually pretty high. First, it needs a real basis in actual safety laws, or the original property deeds. Second, it needs a 2/3 supermajority vote from everyone. Third, and this one is a biggie, it has to be officially registered with the government's Registrar of Societies. And finally, it can only apply to the future, not the past. The RWA in our case study, yeah, they failed on pretty much all of these points.
Which, brings up a great question. We just saw how that tenant surcharge was illegal, but does that mean all differential fees are a no-go? Not at all.
Check this out. This is an example from the very same community. The apartments in a section called Pocket 3 pay a little bit more each month than the villas. And why is that okay? Because the RWA documented the specific unique costs that are only associated with that apartment block, things like the lift maintenance contracts and the generator needed to run them. Because it's based on actual, documented costs, this differential charge is perfectly legal and totally fair.
So after all that, what's the bottom line? What are the key principles that separate a well-run, lawful RWA from one that's just heading for a massive legal battle?
Well, it really all boils down to these 5 clear principles. Rules have to look forward, not backward. Decisions, especially the financial ones, have got to be based on evidence, not just someone's opinion. You have to follow the legal process for making rules. Data collection has to be minimal, only what's necessary. And, maybe most importantly, the RWA's job is to manage the shared courtyard, not to control what happens inside each person's castle.
And this brings us to our final question, and it's one for you to really think about in your own community. Does your RWA see itself as a manager of common assets, focused on keeping up the shared spaces for everyone's benefit? Or has it maybe become a regulator of private lives, overstepping its authority and stepping on your rights? Knowing the difference, that's the first step to making sure your community is governed fairly and legally.